Good morning.
Morning.
To keep us on track, we are going to go ahead and get underway, and I'm going to start off by giving just a few announcements and then turning the podium over to our first speaker, Brydon DeWitt. Many of you already know Brydon. We will try to stay up here in front of the podium where we can be heard a little more easily and recorded. But I wanted to cover a few details with you before we got underway. In the materials that you have, I wanted to point out that toward the back, behind tab 7, there is some information about continuing education. If you do need or would like to get some CE credit, we ask that you sign in at one of our sign-in sheets back there at the desk. Many of you have already done that. And tell us which of the particular continuing ed institutions you need us to submit that to. Also, behind tab 8 is an evaluation form. Just pull that out after you have heard the program, complete that, and we would very much appreciate getting any feedback that you have. There are going to be a couple of boxes there, a couple of trays back at the sign-in desk, and one is for the continuing ed forms, one is for the evaluations. One of the things that we would especially appreciate hearing from you is any topic that would be of interest to you in an upcoming seminar. We're going to bring this back in probably early in 2013, and we would appreciate any kind of direction you can give us on what would be of interest to you. This morning we're going to be talking about two major topics. One is the ongoing saga of Obamacare, the Affordable Care Act, and things that employers and people who advise employers need to be aware of as we go forward. We will follow that after a short break with a discussion on the ongoing requirements of the new fee disclosure regulations. And our speaker this morning is, as I say, well known to many of you already. Brydon DeWitt is our partner in the Richmond office, who is our walking brain trust on the Affordable Care Act and the issues that pertain thereunto. And it's my pleasure to ask him to come up at this point and bring you up to date on that statute. Brydon?
Well, good morning. Hope everyone's doing well. We thought it would be good at least one more time, and it might be the last time, depending on what happens, to go over the requirements of the Affordable Care Act. Now, I've been giving talks like this and advising clients since March 23rd, 2010 on the Affordable Care Act, and often I get the response, all right, how is this really going to work? And this isn't really going to happen, is it? And I think a lot of people thought the Supreme Court was going to strike it down over the summer, and it was a surprising result from the Supreme Court. In fact, the court disagreed with the government's primary argument that under the Commerce Clause, the government had the authority to force people to buy health insurance. And then kind of a throwaway argument that wasn't really briefed very much was the taxing power argument, and that's what carried the day. So it was interesting watching the reaction over the summer that after the Supreme Court decision came out, it was as if the Affordable Care Act had been first enacted. It was funny, I would see on different blogs and different newsletters saying the impact of the Supreme Court's decision. Well, there was no impact because it was the status quo. It had been the law of the land since 2010. So we are, pretty sure this is going to actually happen. I've been talking with our lobbying group in D.C. who are well connected and know how these things work, and they say that if Romney wins and the Republicans hold on to the House of Representatives and win the Senate, that even if the Republicans do not get a filibuster-proof majority in the Senate, 60 votes, that through the reconciliation process, the Republicans could repeal the Affordable Care Act. If you remember, that's how it was passed. Scott Brown was elected in Massachusetts. The Democrats did not have a filibuster-proof majority in the Senate, and so they used the mechanism of reconciliation to pass the act. And so it's possible that the Republicans could repeal it through the same mechanism. But even if the Republicans have a sweep. It would take, repeal would still not be a certainty, and it would take months into 2013 for that to occur. So employers will still have to be complying with the Affordable Care Act and really the hard work of preparing for 2014 when we have the pay-or-play rules, the employer shared responsibility requirement coming into play January 1, 2014. During 2013, there will need to be a lot of activity complying with the Affordable Care Act regardless of the outcome in November. So here we are discussing the requirements of the Affordable Care Act. If you come away with nothing this morning, what I hope you remember is the new requirement for the summary of benefits and coverage. This is probably the first, there are many notice and disclosure requirements under ERISA, but this is, along with the SBC, probably the most significant disclosure requirement that we have in addition to the fee disclosures that Mark will be discussing. The regulations are effective as of September 23rd, 2010. And so it will apply for open enrollments beginning on or after September 23rd of this year. This requirement applies to both grandfathered and non-grandfathered plans. Generally, however, it does not apply to flexible spending arrangements, standalone dental or vision. So if the dental plan or the vision plan can be separately elected by participants from the group health plan, they pay for premiums for that coverage separately from the group health plan, then you do not need to provide an SBC for dental or vision. Generally, it does not apply to health savings accounts because those are personal accounts held by participants. They are not group health plans. But other than that, the group health plans will have to comply with the summary of benefits and coverage requirement. And here's why we care. The penalties can be pretty significant if there's an SBC failure, especially if you have a systematic failure across the board to not provide the SBC or a compliant SBC to participants. It's up to $1,000 per participant penalty. There are excise taxes of $100 per day per failure. So it could be a significant liability if the SBC is not provided. There are two disclosure requirements or disclosees under the SBC requirement. The insurance carrier is required to provide the plan administrator or the plan sponsor a copy of the SBC. That's the insurance company's problem. Our concern primarily is the plan administrator's requirement to provide the SBC to participants. There is an initial SBC disclosure requirement. It has to be provided as part of any written open enrollment materials and provided as of the first date that the participant could enroll in coverage. So again, that means for open enrollment periods beginning after September 23rd of this year, September 23rd of this month, the SBC will have to be provided along with any written documents that are provided along with open enrollment. If written materials are not part of the open enrollment, if the open enrollment is entirely online, then the SBC has to be distributed as of the first date that a participant could go online and enroll for coverage under the plan. If there is a change in the SBC between open enrollment and the first date of coverage, so let's say you have open enrollment beginning October 1 to October 14th, and then you may decide to make a change in the plan effective January 1 in November, then you have to provide an SBC, another SBC, an updated SBC before the first day of the plan year. So if you made a change, decide to make a change after open enrollment, you'd have to immediately send out an SBC, a corrected SBC. So that's the initial SBC requirement. Special enrollees, people who enroll for coverage under the plan mid-year. So if they have a HIPAA special enrollment right, they have a qualifying event under the 125 regulations, or they're a new hire, then the SBC has to be provided at the same time that you provide an SBC. I'm getting my acronyms mixed up. The SBC has to be provided at the same time you provide the SPD, and that's 90 days after you become eligible for coverage under the plan. And then also you have to provide it upon request within 7 days of a request for an SBC. So that would be what we're going to do for 2013, right? So we provide the SBC through open enrollment. In 2013, we have a special enrollee. We provide the SBC within 90 days. We provide it upon request within 7 days. Next year, we would also have to provide it during open enrollment. You have to provide the SBC no later than 30 days before the first day of the plan year. If you can provide a single SBC for a family, so if you know that the family, the spouse and dependents live with a participant, you can just provide one SBC. But I think most plans are aware of the SBC requirement. It's coming up pretty soon. But what I've noticed with clients is they're relying on their TPAs. So we'll say, how are you doing on your SBC? They say, well, their self-insured plan. They say, well, Anthem or Aetna, they're providing the SBC. The regulations allow you to rely on the third-party administrator or the insurance company to provide the SBC to the participants. Well, let me put it this way. An insurance company is required to provide the SBC to participants. Separately, a plan administrator is required to provide the SBC to participants. But participants aren't required to receive two SBCs. So if you know the insurance company is providing the SBC, the plan administrator does not have to provide a duplicate SBC. But the thing to be concerned about here is that the plan administrator is still on the hook for providing a compliant SBC. So if you're relying on the insurance company or you're relying on the third-party administrator to provide an SBC, you have to make sure, you really should be reviewing the SBC to make sure that it complies with these requirements. Because if you rely on the TPA to provide the SBC and it's not compliant, it's not their problem. Well, it may be their problem, but it's definitely going to be the plan administrator's problem. So I'm worried about clients who just say, well, the TPA is providing it, it's off our worry pile. It still needs to be on your worry pile. You need to get a copy of that SBC now so that you know that by open enrollment starting after September 23rd that a compliant SBC is going to be provided on behalf of your plan. Okay, so the SBC has to provide on 4 pages all of this information. Uniform definitions, descriptions of coverage for each category of benefits, cost-sharing provisions, description of COBRA, continuation of coverage requirements, hypothetical coverage examples, and the final regulations say that you have to provide at least 2 hypothetical coverage examples, and those, the ones you provide have to include having a baby and managing type 2 diabetes. So most SBCs are going to describe having a baby and managing type 2 diabetes, and those will be the 2 examples. An internet address for a network of providers if the plan has a network, internet address for prescription drug coverage, an internet address for a uniform glossary of coverage, which we will also discuss in a moment, a statement that paper copies are available, premium or cost of coverage information, a statement that the SBC is only a summary of plan benefits and not the plan document, contact information for obtaining a copy of plan documents, and then goody, in 2014 we'll have additional information to include in the SBC. So again, all of this information has to appear on no more than 4 double-sided pages in 12-point font. Now, being a lawyer, I'm looking for loopholes, right? And so the regs say no more than 4 double-sided pages in at least 12-point font, but nowhere in the regulations does it specify the size of the page. So I'm thinking we could have maybe something this big. Okay, here's your SBC. It can be a standalone document, or you can also include it in your SPD. If it's in the SPD, it must be your SBC provisions also have to be in one place, so you can't sprinkle them throughout the SPD. So it needs to be a defined area of your SPD that contains the SBC requirements, and it needs to be prominently displayed at the beginning of the SPD. So you can't hide it, you can't sprinkle it throughout your SPD. You need to have an SBC section of your SPD. It has to meet the linguistically appropriate requirements under PPACA. And this is a requirement that I think is often overlooked, but it could be a nightmare for a plan administrator. If you have employees in a county where at least 10% of the population, their primary language is a non-English language, then you have to provide linguistic services. That means you have to have an SBC provided in that alternate language, whether it's Aleutian, Eskimo, or probably it's going to be Spanish or Chinese or whatever it is. You have to have an SBC that meets those requirements. Your SBC has to provide in that alternate language, the other language, disclose the availability of the SBC in the other language. The regulations have a list of counties that the government has identified as being eligible for this. So that's something for plan sponsors to really pay attention to. I think that could be missed. And fortunately, the Department of Labor has issued a model SBC, and it's available on the Department of Labor EBSA website. So there is a model template that plan sponsors can use for their SBC, or TPAs are using. The SBC can be provided electronically in accordance with the Department of Labor electronic disclosure regulations that apply to SPDs. So if you have a workforce that works primarily, they use a computer in the daily course of their employment, you can send them an email with the SBC attached and with the disclosure that this is important information. You can receive a paper copy, etc. So you can provide the SBC electronically if you meet those requirements. Along with the SBC requirement is the new 60-day advance notice of modifications requirements. Before PPACA, before the effective date of this requirement, you had to provide notice after you've made a change to the plan. Now, if you make a material modification to your group health plan that affects the contents of the SBC, participants must receive a notice 60 days in advance of that change. And there are significant penalties, potential penalties for failure to do this. So now if you're going to make a change mid-year to the group health plan, you need to know you're going to make the change at least 60 days in advance and provide the notice. Along with the SBC, plan sponsors must have a uniform glossary and post it on the internet. The glossary defines general health plan terms. The regulations provide a list of terms you have to define. So examples of terms are co-payment, deductible, emergency services, medically necessary, out-of-pocket limit, insurance. There's a laundry list of terms that must be defined. It has to be posted on the internet. If you have an intranet site, it has to be provided upon request within 7 days, electronically or in paper. All right, so those are the new disclosure requirements, the immediate new disclosure requirements under the Affordable Care Act. And hopefully plan sponsors are ahead of the game and ready to comply with those requirements coming up very shortly, September 23rd of this month. So moving on to some coverage changes that are occurring this year and in the next couple of years. The annual dollar limit allowed under plans is phasing out. For the current plan year, the limit is $1.25 million. For the next plan year beginning after September 23rd of this month, the maximum annual dollar limit moves up to $2 million, and then it goes away. The limit applies to what PPACA terms as essential health benefits, and we still do not have clear guidance from the government as to what the term essential health benefits means. Proposed regulations issued over the summer by the Department of Health and Human Services explained that essential health benefits will be on a state-by-state basis using state benchmark plans. And so they're going to look at the top 3 insurance carriers in the small group health plan market, look at the plans that they offer, or the insurance coverage they offer, and they will come up with a benchmark plan that will provide defining what essential health benefits are. So they're going to collect data such as what are covered benefits, what are the treatment limitations under the plans, what are the deductibles, what are the co-pays, what are the covered drugs, do you have to get prior authorization. All of these terms are going to be looked at to define a benchmark plan, and that's going to be state by state, which kind of goes against what we're used to with ERISA, right? I mean, ERISA, the idea was we have a federal regulation of benefits, we have uniform requirements throughout all 50 states, but now we're going to have these essential health benefits defined kind of on a state-by-state basis. Likely the plans will be similar. A coverage change that has been in the news lately has been the requirement to provide coverage, first dollar coverage for preventative services. This requirement only applies to non-grandfathered plans. Every year, the government produces a list of preventative services. The U.S. Preventive Services Task Force issues recommendations, and then the recommendations issued by the task force are then applied to plans a year later. So the plan you're beginning a year after the list is issued is when you have to comply. So for example, items that are on the list right now include aspirin for cardiovascular disease, smoking cessation products, fluoride for children to prevent cavities, iron supplements to prevent anemia, folic acid, and the list, I mean, it's like a 3-page list, but those are the types of things that plans currently have to provide on a first dollar basis under the preventative coverage requirement. The item that's gotten a lot of attention is the requirement for what they call women's preventative services, which include the requirement to provide first dollar coverage for FDA-approved contraceptives and counseling. Of course, there's been a lot of controversy over that, and there's been litigation. And currently, there is a 1-year safe harbor for nonprofit organizations to not provide coverage for the contraceptives for at least another year, until August 1 of 2013. There has been litigation. In fact, there was a case in Colorado where a for-profit private employer challenged this on First Amendment grounds and got an injunction at the district court level. So there's a lot to be seen over the next year as to whether this requirement will survive a constitutional challenge. But in addition to the contraceptives, plans have to provide well woman visits, including pre-conception and prenatal care, gestational diabetes screening, HPV DNA testing for women 30 and older, sexually transmitted infection counseling, HIV screening and counseling, breastfeeding support, supplies and counseling, and domestic violence screening and counseling. So this is something that plans on an ongoing basis will have to keep track of and be sure that they know that their plan is complying with the recommendations issued in the prior year. As what is apparently a revenue enhancing measure under PPACA, flexible spending arrangements are going to be capped at $2,500. This cap applies only to employee contributions. So if employers may give flex credits or provide contributions to FSAs, those credits and contributions do not count against this cap. It only applies to the employee contributions. It's effective for plan years beginning on or after January 1, 2013. So fiscal year plans, even though the effective date of this requirement is January 1, the effective date for a fiscal year plan would not be until the beginning of the plan year or first day of the plan year that begins in 2013. Plans have a grace period to amend for this requirement until the end of 2014. So although my clients are amending their plans now, just to have it in the plan document and make sure we get it done, a plan administrator or plan sponsor could wait until the end of 2014 to retroactively put the cap in place as of January 1 or as of the first day of the first plan year beginning after January 1, 2013. If a plan has a grace period, as you may know, a flexible spending arrangement has a use it or lose it rule. So if you don't use the amount in your account by the end of the plan year, you lose it. Some plans have a grace period of 2.5 months where you can incur additional expenses up to 2.5 months after the end of the plan year and still use the prior year's balance to pay for those expenses. If a plan has a grace period, that does not count against the 2013 $2,500 cap. And then there's also relief available if a plan exceeds the cap due to a reasonable mistake. So we have received recently, this is all pretty new guidance under the FSA cap. In 2014, the maximum waiting period, eligibility waiting period, will be limited to 90 days, and then there will be no pre-existing condition exclusions permitted. Currently, there are no pre-existing condition exclusions permitted for children 19 years or under. In 2014, pre-existing condition exclusions go away entirely. These are the type of provisions that even if the Republicans win, I think these types of provisions will probably be preserved in whatever, if we have repeal and replace, well, the replace will probably include, likely to include these requirements even if PPACA is repealed. PPACA subjects fully insured plans to the Section 105H non-discrimination rules. Before PPACA, only self-insured plans had to worry about these rules. Section 105H requires plans to be non-discriminatory as to both eligibility and to benefits. The eligibility rule generally is satisfied if at least 70% of employees are eligible to enroll in the plan. The benefits test is met if all participants, if all benefits provided to highly compensated individuals are also available to non-highly compensated individuals, the plan will pass the benefits test. This requirement will apply to insured plans under PPACA. The IRS delayed enforcement of this requirement until it issues regulations. We do not yet have regulations. But once we have regulations, insured plans for the first time ever will have to comply with the Section 105H requirement. And I've discussed this with several clients who have historically provided richer benefits to high paids. They may fully subsidize the premium for their high paid employees, their executives, and not for their rank and file. And they're going to have to change how they structure their health benefits once we get regulations. PPACA requires employers with over 200 full-time employees to automatically enroll all new hires, and then during an open enrollment, default participants into coverage. So to automatically enroll people into health plan coverage. Interestingly, you would think PPACA was a model of legislative drafting. It wasn't. This provision did not have an effective date, and so under normal rules of statutory construction of interpreting what a law means, this requirement was effective March 23, 2010, and every employer in the United States that did not have automatic enrollment was in violation of PPACA. Fortunately, we have guidance from the Department of Labor that enforcement of this requirement is also delayed until they issue regulations. It's anticipated this will be effective in 2014. So 2014 is not as far away as it used to be. And so pretty soon this will be a significant administrative change for plan administrators, that they will have to start automatically enrolling pretty much everyone into their plans in 2014. The comparative effectiveness research fee. This fee is intended to pay for the work of the Patient-Centered Outcomes Research Institute. And the Institute will conduct research evaluating and comparing health outcomes, effectiveness, risk, and benefits of medical treatments. The fee is $1 for every covered life under the plan for plan years beginning on or after September 30th of this month. And then in future years it's $2, and then it's going to be indexed for inflation. It phases out by 2019. So this applies both to insured plans and self-insured plans. A calendar year plan will be required to first pay this fee for the plan year beginning this year, for this 2012 plan year. The fee is due annually by July 31 of each year. You file what's a IRS Form 720 and pay the fee by July 31. So calendar year plans will have to pay this fee by July 31, 2013. We don't yet know exactly how to calculate the fee, however. The IRS has floated 3 safe harbor approaches. One would be you would actually count your participants. One would be you'd use a snapshot date, and they provide guidance on how to do that. And the other would be just to calculate it based on what is on the Form 5500 for that year. So the number of active participants under the Form 5500. This payment does not apply to standalone dental or vision coverage. It doesn't apply to EAPs, disease management, or wellness programs unless those programs actually provide medical care. Retiree coverage is subject to the fee. So we need to be calculating and taking into account this new requirement, and it's due in July of next year. There are new claims procedures for non-grandfathered plans. They're already in effect. This is a new requirement. Again, I want to just highlight the culturally and linguistically appropriate requirement that if you have employees in a county that at least 10% of the population speaks a non-English language as their predominant language, then you have to provide language services in connection with your claims procedures under the plan. For small employers with under 100 employees, they can offer a simple cafeteria plan. If you provide a uniform percentage of employer contribution, that's a uniform percentage of compensation, or a contribution that's the lesser of 6% of pay or 2 times salary reduction contributions, the plan is deemed to comply with all of the section 125 non-discrimination requirements, and also the section 79 requirements for life insurance and all the various other non-discrimination requirements for qualified benefits under a cafeteria plan. Before this rule came into play, a lot of smaller employers were not allowed to have cafeteria plans because they couldn't meet the non-discrimination rules because of the size of their workforce. I think this is really an opportunity for small employers to provide benefits on a pre-tax basis. The wellness program cap, currently your wellness reward may not be more than 20% of the cost of employee-only coverage, or if family members are allowed to participate in the wellness program, the reward may not exceed 20% of the cost of family coverage. PPACA statutorily increases the limit to 30% in 2014, and then the Secretaries of Labor, HHS, and Treasury have authority to increase the wellness program limit up to 50% of the cost of coverage. So this is an effort to focus on, again, preventative care to reduce healthcare costs. Next year, by March of next year, employers have to provide notice to employees regarding health insurance exchanges, the availability of the premium tax credits and subsidies, and this is required if the employer's share of cost is under 60% of the allowed cost of benefits. So employers very soon need to be determining whether they are offering affordable coverage that provides essential health benefits in 2014, and if not, in 2013, they have to notify employees of the availability of the state exchange. And then everyone's favorite topic, the penalties in 2014. In 2014, a large employer will pay an excise tax if any full-time employee purchases coverage through a state health insurance exchange, the employee is between 100% and 400% of the federal poverty line, which means the employee is going to be eligible for premium subsidies and tax credits to receive coverage. And so you have a full-time employee, he goes to the exchange, he's between 100 and 400% of the federal poverty line, and the employer either does not offer any health care coverage, or the employer offers coverage that is either unaffordable or doesn't meet the minimum value requirement. Unaffordable means that the premium the employer requires the employee to pay exceeds 9.5% of household income, or the minimum value requirement is that the coverage does not provide, it doesn't cover at least 60% of healthcare costs. So the employee, which is really unusual for health insurance, you wouldn't really buy health insurance if it didn't do this, but the employee is paying over 40% of the cost of the coverage of the healthcare coverage. So if you have 50 employees, an employee who's up to 400% of the federal poverty line gets subsidized coverage through an exchange, and the employer doesn't offer adequate care, then the employer is going to pay a penalty. If the employer doesn't offer any coverage or doesn't provide coverage, provides essential health coverage, the fee is $167 per month multiplied by the number of full-time employees in excess of 30. So if you have 60 employees, the fee would be $167 times 30, because 30 excess of 30 employees. And so that works out to $2,000 per year per employee in excess of 30. If the employer offers coverage but it's either unaffordable or does not provide minimum value, then the fee is $250 times the number of employees receiving coverage assistance through an exchange. So it's not multiplied by your total number of employees. is $250 times the number of employees receiving premium assistance through an exchange. So to understand whether an employer is going to owe the employer shared responsibility payment, it's important to know who are your full-time employees. And the packet defines a full-time employee on a monthly basis. It's an employee who averages 30 hours of service per week. 130 hours in a month is deemed to be a full-time employee. And it's on a month-by-month basis. This is really difficult for employers to administer without some guidance, especially if you have seasonal, temporary, you have a high turnover rate. And so recently, just about 2 weeks ago, the IRS finally issued some guidance on how an employer can determine who its full-time employees are. And the idea here is to use what they call a standard measurement period and then a stability period. And so it's a look-back rule. So your standard measurement period is you look back, and it can be a period of 3 to 12 months, and look at the hours the employees worked during that standard measurement period. And employees who averaged 130 hours per month or 30 hours per week during your standard measurement period, you can then treat them as full-time employees during your stability period, which can be at least 6 months, but cannot be less than your look-back measurement period. So you don't have to determine your PACA compliance on a month-by-month basis going forward. You can look at a measurement period, determine who those employees are, and then treat them as either full-time employees or not full-time employees going forward during what's called a stability period. For seasonal and variable hour employees, you can use what's called an initial measurement period that begins on the date of hire. And it's still kind of the same mechanism where you watch them for 6 months or 9 months, you determine what they are, and then you apply the stability period going forward. So I'm not going to get too much in the weeds on this, but I think it's important to realize this guidance is out there. I think it's helpful, and we finally have a way to determine who the full-time employees are, and we need to start capturing this data in 2013 so we know who the full-time employees are in January 14 when the pay-or-play rules come into effect. And so with that, I think we have a break, and then we'll turn it over to Mark.
Do any of you have any questions? This is a good opportunity to pick the brains of someone who's well informed on this subject. We can take Q&A now, or we can take questions also at the end of the program.
Yes.
Just have a quick question about responsibility for enforcement. Which federal agency is going to be responsible for tracking all this?
The IRS is going to, the shared employer responsibility is the IRS. Yes.
For employees that have pre-existing conditions, can you charge an extra fee, a higher fee?
Now, and that would be prohibited under HIPAA. That would be a health factor discrimination. Okay.
All right.
Thank you.
Let us take a break. We'll get underway about
I hear a number of interesting questions about Brydon's topic. No question for the next several months, if the statute survives, then we're all going to be living into how to apply and implement that major healthcare reform act. Much the same thing can be said of our next topic. It would be perfectly understandable if several months ago someone had said, well, okay, I got it. I understand what the covered service providers are supposed to do. I understand what the responsible plan fiduciaries are supposed to do. I need no more reminders about the new fee disclosure regs. It would have been forgivable if someone had said that 6 months ago. But as we study the regulations, as we listen to all of our compadres through the websites talk about this, as we have now actually gotten through the effective dates and the initial disclosures that occurred this past summer, We see that there remains more to study, at least for the time being, with regard to the Department of Labor's fee disclosure regulations that went into effect on July 1st. As we've heard, the basic objective of these regulations is to address duties that the fiduciaries have under Section 404A, especially 404A5 of ERISA, and the prohibitions against certain types of self-dealing transactions under 408B2 of the statute. And one of the basic objectives of these new disclosure regulations is to require the covered service providers to provide the responsible plan fiduciaries with information that those fiduciaries need to assess the reasonableness of a service provider's compensation, both direct and indirect, to identify potential conflicts of interest, to satisfy the fiduciary's own reporting and disclosure requirements for these individual account plans. Most of what I'm going to be saying is about 401k plans, but broadly speaking, it applies to the individual account plans with a few exceptions. The providers, and if I say CSPs, I'll be talking only about covered service providers. Likewise, if I say the RPFs, that'll be the responsible plan fiduciaries. The providers, of course, were required to furnish their initial disclosures under these regs on July 1st, and the fiduciaries were required to disclose the necessary data to the affected participants and beneficiaries by August 30th of this year for at least all calendar year plans. However, many surveys that were conducted last year and in the months leading up to the effective date found that at least a third of all employers did not understand what their disclosure duties were. And many employers may feel even less comfortable after this past summer's experience of the initial disclosures. And it did not end there. This morning we're going to review some ongoing duties imposed by those regulations on both the providers and the responsible plan fiduciaries. And as we will see, while there may not have been an uprising or a war dance by participants this past summer, the upcoming disclosures, the quarterly disclosures that begin in November and other duties that are now in place, may trigger the questions, the searching questions and issues that do not appear to have arisen immediately back in the summer. We're going to talk first about the service providers, and we're going to recognize that the disclosures impose certain duties that were very independent of the initial disclosure deadlines that kicked in this past summer. When the fiduciaries of a plan make a written request for it, the covered service provider is required by the regs to provide the information that that fiduciary will need in order for that fiduciary to comply with his own filing and disclosure requirements. That's a benchmark, that's a touchstone for every service provider. They have to understand that basically what they're called upon to do is to provide the information coming from them that will enable the fiduciary to comply with the statute. For example, a written request from a fiduciary for the data that the fiduciary needs to complete the Schedule C for a Form 5500, among other things. The fundamental rule for the timing of all this is that the provider has to give the information to the fiduciary reasonably in advance of the date that the fiduciary himself will need to make his own filing or disclosure. Unless that disclosure by the provider is prevented due to extraordinary circumstances beyond the provider's control. Now, by that word choice, we would expect the services to say, we don't expect that kind of situation to occur very often. We expect the providers to have their own data gathering in an orderly process and to be able to predict and provide the information in a timely way most of the time. There will have to be something really extraordinary to prevent that. The unfortunate thing is that they're trying to be flexible, and they use terms like reasonably in advance of the date, but they don't give exact precision. So it's going to be a rule of good faith. What is the date that the provider knows that information is due? And this is a two-way conversation. The fiduciaries do need to let the providers know what information they need and when they need it. They should allow themselves at least a reasonable time to process it. One would expect that the more information that the provider is going to be given, the more time you need to allow the fiduciary to process it, to interpret it, and then put it into the form that the fiduciary has to report. There are going to be situations recognized by the regulations where at the time that a contract or other investment product or entity was entered into, the contract or product or entity did not hold plan assets. But later, plan assets may come into that particular vehicle. When the provider notes that there are now plan assets in the product or arrangement, the contract or entity, then the service provider has to disclose the required information to the responsible plan fiduciary as soon as practicable, but not later than 30 days after the covered service provider learns that the contract or product or entity holds the plan assets. Now, of course, these disclosures that the fiduciary is required to make pertain to designated investment alternatives of the plan. And it may be that initially the investment option is not a designated investment alternative. Maybe it's a mutual fund or some sort of brokerage window. But it may be later designated as a DIA by the responsible plan fiduciary. When that occurs, then this particular rule kicks in. And so there again has to be an ongoing conversation between the covered service provider and the responsible plan fiduciary so that they are not surprised. So much of the requirements and the disclosure obligations that we're going to be talking about can be avoided by just an ongoing communication, a clear communication between the service providers and the fiduciaries, rather than either side getting into an argument over whose obligation is that. It would be wise, of course, on the part of the providers as well as the fiduciaries to initiate periodic contacts and to make sure that they can review the situation and that they know, for example, when an investment alternative has now been raised to the level of a designated investment alternative that might trigger this particular obligation on the part of the service provider. There are going to be situations, inevitably, where the covered service provider has given accurate fee and expense data, but then that changes. There's some change in the data. And at that point, the covered service provider has to disclose the new data, the corrected, updated information, to the plan fiduciary not later than 60 days after the covered service provider learns of that. This is subject to another exception in the regulations. If the service provider discovers the changes and he was not able to learn of it sooner because of extraordinary circumstances beyond the covered service provider's control, then he must report the change to the fiduciary as soon as practicable. But again, by that word choice, extraordinary circumstances beyond the service provider's control, we see that the agency doesn't expect this to happen too often. So that's not an excuse that any covered service provider should be invoking very frequently. Yes. Go ahead, Denise.
You've got a 401k plan that is making fund changes, replacing Fund A with Fund B. As a covered service provider, I'm aware of that 45 days in advance because I've got to give 30 days notice to the participants. So no later than 15 days after the fund change takes place, I have to have a new disclosure back to the plan sponsor because that's kind of our awareness window. Is that a fair interpretation?
Yes, and I'm going to try to repeat that since we're trying to record this, but you've given a scenario where the fiduciary changes from like Fund A to Fund B. There's a change in one of the funds, so naturally the fee and expense data will likewise be changing. The notice of that to the participants has to be given at least 45 days before that takes place, that change from the Fund A to Fund B takes place. So you're asking whether under this particular rule, where the service provider has to give the new fee and expense information not later than 60 days after he's informed of the change, whether that would mean that the fee and expense information, the new data from the service provider would have to come in about 15 days after the participants are informed of it, after the actual change takes place. Actually, the standard rule is that the information by the fiduciary has to be given to the participants and beneficiaries not later than the first day that they can begin to direct their investments. So if you take it that they're told about that information at that point, then you have to back up from there, and that may mean that in fact you're dealing with more than 45 days. 45 days, I believe, would be the minimum, but to square it with this particular requirement for the service provider, you probably need to allow more like 60 days or more before the actual fund change occurs. Does that answer that question? Okay. Yeah, that's a good question because it does show that there are a number of moving parts here. The fiduciary, again, is really the touchstone. Remember what we said a few minutes ago. What the service provider is doing is trying to provide information the fiduciary needs to carry out his job. And if the covered service provider always tries to see what the minimum amount of work is that he can get away with, there are going to be some problems. Again, if you interpret these from the standpoint of the service provider trying to get the information to the fiduciary timely enough that the fiduciary can do his job, then generally these regulations can work. But it is, of course, critical that everyone be aware of these types of rules, like this one here, so that they can be alert to the events that might trigger one of their disclosure responsibilities. Now, we talked just a moment ago about when there's a change in the data, what happens when, in all good faith, the covered service provider provides fee and disclosure data and he just got it wrong. Either he got the wrong numbers, maybe the arithmetic is off, or he left out a number. We all know that these kinds of things can happen. They may not happen as often as getting it right, but they do occur from time to time. What happens if he completely leaves out certain information? When the covered service provider discovers that there is an error in the disclosures to the fiduciary, or he's failed to make even any required disclosure on certain fees or expense information, he has to disclose the correct information to the fiduciary 30 days after he found out about the error or oversight. 30 days is a reasonable amount of time, but it can run by very quickly. So this again requires some good processes and procedures in place for the covered service providers. First of all, of course, if they have enough quality control in place, one will hope that they did not make any major errors. But if they do find one, they have to act pretty promptly to stay within this 30-day window. Okay. A couple of words to the wise as it pertains to the covered service providers. These are the disclosure rules, what we've gone over here for the service providers so far. But again, the benchmark of all this is that the service provider is supposed to be trying to help the fiduciary carry out his job. And if the fiduciary finds that the covered service provider gave incorrect information or failed to give certain information that was required, the fiduciary has got to make a demand in writing on the covered service provider. And if that service provider fails to cure the problem within 90 days, the fiduciary must report that failure to the Department of Labor. We'll come back to that in a few minutes when we talk about the fiduciary's own obligations. So the service provider is now under more of a microscope than he was before, as of July 1. This is for all of these disclosure requirements rolling forward. We've covered a number of them already that directly pertain to the service provider, but you're going to see in a few minutes some ongoing duties of the fiduciary that are not linked to a particular date on the calendar. They could just come up when a participant makes a request for information, and that may then trigger in turn a request by the fiduciary to the service provider. So the covered service provider has to be aware now that there is a real possibility that he may be reported to the Department of Labor if he fails to respond appropriately to a request for information from the fiduciary. In some cases, it may just be a misunderstanding. The provider may be able to say, I did give you that, look on this page under that paragraph. It may be an innocent mistake where a certain amount of information was left out or some arithmetic was mishandled and it can be quickly corrected. But the covered service provider should take all of these kinds of requests very seriously from the fiduciary, because the fiduciary knows that if he doesn't make that request, then he himself is subject to a violation and liability for violating the prohibited transaction provisions under ERISA Section 408. And that makes it much more likely now that the fiduciaries will be trying to cover themselves by putting the demand on the shoulders of the service provider. One more word to the wise. Just remember again the basic rule that we started off with. This is the rule that the fiduciary has to comply with, so the service provider has to be aware this is going to be the measuring stick that the fiduciary should be applying to all of the contracts or arrangements with the service providers. Under Section 408B2, the fiduciary is obligated to determine that every contract or arrangement with an outside provider is reasonable, that the services are necessary to the operation of the plan, and that the provider is paid no more than what is reasonable compensation for those particular services. If it doesn't meet this test, then a prohibited transaction has occurred, and the service provider as well as the fiduciary can be subject to excise taxes under the code. So again, while the service provider, just as a professional, is seeking to always provide accurate and complete information, the provider should be aware at all times of this rule that's over the head of the fiduciary and serve the provider's own self-interest as well as the fiduciary's by making sure that whatever information is provided can help the fiduciary meet this test under Section 408. We're now going to turn to the disclosure rules for the responsible plan fiduciaries. Now, that last slide talking about the service providers is a natural transition because, again, for many, many years, for decades, the fiduciary has already been subject to that prohibited transaction rule to make sure that any outside contracts or arrangements are reasonable, necessary for the operation of the plan, no more than reasonable compensation. The regulations now are determined to make sure that the fiduciaries are fulfilling these obligations. And you and I have talked before, many of us, about the cases that have been going on for now 5-6 years or more, the excess fee lawsuits that have spurred so much of the work that led to these regulations. Tough cases make tough law sometimes, and this is an example of where there's much more scrutiny on all of the plan fiduciaries to make sure that they can demonstrate to their participants and beneficiaries that they are actually fulfilling their job and making sure that no one's getting more of a sweetheart deal than is permitted under the plan, that the plan itself is not spending its plan assets on anything other than contracts or arrangements with service providers who are needed to help the plan fulfill its duties to the participants and beneficiaries. So again, the fundamental rule that we are becoming familiar with, the one that kicked in with the initial disclosures this summer for fiduciaries, is that they have to disclose to the participants and beneficiaries plan-related information, administrative expenses information, and the fees and expenses that were charged against the participants' or beneficiaries' individual accounts. And they have to give this on or before the date that the participant or beneficiary can first direct his or her investments, and at least annually thereafter. This information has to spell out the name and type of each investment. Of course, this is a very quick summary of what you know is going to need to be in there. It has to include performance data for fixed and non-fixed investments, the general chart formats and the model disclosures that the IRS and Department of Labor provided are in your materials as supplemental materials, and you're familiar with them by the disclosures we went with this past summer. So you see that the fixed and non-fixed investment performance data has to be set out separately. There has to be relevant benchmark information. and there has to be fee and expense information for all of the investments. It is interesting to note how much effort the Department of Labor has gone to put out information for participants and beneficiaries for free on the Department of Labor website. Some of your other supplemental materials include, for example, a 5-page explanation that's entitled How to Maximize Your Retirement Savings, Tips on Using the Fee and Investment Information from Your Retirement Plan. So now that they got it a few weeks ago for the first time, participants and beneficiaries are being urged to actually look at it and to ask questions. There's also in your supplemental materials another Department of Labor handout, frequently asked questions on disclosures to help employees understand their retirement plan fees. And of course that model comparative chart, which they can use as a measure against what their employer plan administrator actually handed out to them and see if they got all the information that the Department of Labor tells them they were supposed to be getting. One of the basic questions that has confronted every plan fiduciary who's made the disclosures is identifying the employees who must receive the disclosures. They have to be given to eligible employees, and that includes not only those who are actually employed and enrolled in the plans and actually have a plan account with funds in it to be invested, but it would include new hires and employees who are eligible for the plan but not yet participating in it. Here's the reason why I say that. The regulations do require that the disclosures be given to every participant and beneficiary, as we said, on or before the date that that person can first direct his or her investments, and at least annually after that. ERISA defines a participant as someone who is or may become eligible to receive a benefit of any type from an employee benefit plan, who is or may become eligible. That's under Section 3, subsection 7 of ERISA in the definitions. Back on October 20, 2010, in the final regulations that were published by the Department of Labor, specifically in the preamble to those final regs, we found the department giving the broadest definition of who a participant was that was eligible to receive the disclosures. I'm going to quote to you a little bit at length in that, but you will probably recall this language. The department was discussing in that preamble the comments that it had gotten during the public comment period about the proposed regs before the final regs were issued in October 2 years ago. And here's a pertinent section that the department included in that preamble. The question presented by the commenters, says the department, was whether disclosures must be furnished to all eligible employees or only those who actually participate in the plan. Consistently with the definition of participant under Section 3.7 of ERISA, disclosures must be made to all employees that are eligible to participate under the terms of the plan without regard to whether the participant has actually become enrolled in the plan. One commenter recommended that the proposed rule be modified to require initial disclosures to all eligible employees, but limit the annual disclosures only to those that actually enroll and make contributions and direct their investments. The department has not adopted this recommendation. The department believes that with regard to employees who have not enrolled in their plan, the annual notice will serve as an important reminder of their eligibility to participate in the plan. With regard to notice to beneficiaries, however, the obligation to disclose extends, says the department, only to those beneficiaries who, in accordance with the terms of the plan, have the right to direct the investment of assets held in or contributed to their accounts. They're actually enrolled. And such rights might arise as a result of the death of a participant or pursuant to a qualified domestic relations order. So we have to remember the beneficiaries and alternate payees. From all of this, we can see that there is a time after an employee is hired, but which may be before the time the employee enrolls as a participant, when the responsible plan fiduciary has to give that employee the disclosures, the fee disclosures that we've been talking about. And definitely it must not be later than the first date the employee could actually direct his or her investments. Of course, by that time they would be enrolled in the plan. Now, the initial disclosures that were due to participants and beneficiaries on August 30th were subject to certain transitional rules under 404A5J3 of the regulations. And it is arguable that under those transitional rules, a fiduciary could reasonably interpret them to cover only the participants who actually were enrolled in the plan and thus had individual accounts in which they might invest. But as we've seen from that preamble from the final regs 2 years ago, the DOL has taken a broad view of who is an eligible participant entitled to get the disclosures. So this would appear to mean to us, certainly going forward, with the quarterly disclosures and the others that become due even on a non-specific calendar date, that the disclosures are due not only to existing plan enrolled participants, but also to new hires and to those employees who are eligible for the plan. They're not new hires, but they've been on board for a while, but they simply haven't enrolled in the plan and they're not yet participating. And it would be logical to conclude that the quarterly disclosures, it would be safer to go ahead and give those disclosures even though they are due only to tell you the dollars and cents that have actually been charged against your investment account in the preceding quarterly period. It would still be safer to give the disclosures even if that means nothing was charged. Because again, if we look back at the wording of the preamble, it would be a reminder to that person who's not yet enrolled in the plan that they are eligible to enroll in the plan. So for those who thought they may have had all of the census data and identified all of the participants and beneficiaries who were supposed to be getting the disclosures back in August, I would recommend that you go back and revisit that list and take a broad view of who should be on it. Let's talk about the quarterly disclosures a little more in detail. At least quarterly, the plan fiduciary has to give participants and beneficiaries a statement that includes the dollar amount of the administrative fees and expenses and the individual account fees and expenses that were actually charged during the preceding quarter. For calendar year plans, that would be the quarter ending September 30th, and that means the first of these quarterly disclosures would be coming up on November 14 of this year. But the regs do say that the quarterly disclosures have to be made at least once in any 3-month period, without regard to whether the plan operates on a calendar year or a fiscal year basis. Now, the initial disclosures just went out on August 30th. It would be prudent for every plan fiduciary to make sure that the quarterly disclosures go out within 3 months of that time, even if it's not a calendar year plan. And then to make sure that every 3 months after that there is a new quarterly disclosure. This is an interesting point to pause and to say that certainly in the blogosphere, the long-anticipated earthquake, the uprising and tribal war dance of the participants and fiduciaries, which was feared by many after the August 30th initial disclosure went out, has apparently not occurred. At least we have not heard of the earthquake yet. There was no more than, say, a tremor, in the words of some commentators. The charts, comparative charts of information may have simply overwhelmed the readers with too much information. They may have been very unfamiliar with what basis points are. They may have simply lacked enough of a history of reading these kinds of data to sense whether the benchmarks were relevant and to really discern what they were being told, to get an idea of whether they had a good deal or a bad one. But these first quarterly statements are of a different character, and they may actually trigger a stronger reaction, because, as we've noted, they have to be stated in terms of dollars and cents. And someone may not understand the difference between 5 basis points and 10 basis points, but they can understand when you tell them that $238.15 was taken out of their account, or whatever it might be. So plan fiduciaries, prudent plan fiduciaries, would be prepared to respond to a number of questions. Again, we've noted that the DOL is already putting data out there if a plan participant wants to dig in to a deeper understanding of what these fees and expenses are, especially if they did not realize until this summer that there actually were administrative fees and expenses. And the fiduciaries, with the help of their covered service providers, need to be ready for questions that ask them, why am I paying anything? Why have the charges gone up, as they get more of these quarterly statements and they see more or less being charged against their accounts, and all the other types of questions that you see being suggested to them by the Department of Labor in those handouts. Yes, Greg, go ahead.
In relation to this slide, we anticipate exactly what you just said. We started doing this in January, the June quarter statements, and that's somewhat been a non-event. We've been disclosing this already back in June. So I'd be interested to know what others might have experienced. We thought this would put the rubber to the road.
Yes.
When it showed up on the business statements, but it's been somewhat of a non-event.
And Greg is mentioning that with his bank, they actually put the first quarterly statement out for the quarter that ended June 30th of this year. So they were a quarter ahead of time beyond what they had to do, and they have not gotten a strong pushback, a lot of questions. And have any of you in the audience had any other feedback in your situation? Have you heard of colleagues or others in the community who have been getting any kind of strong pushback from people asking questions about the quarterly statements? Let me say that while they say it takes 2 points to make a straight line, it may take 2 quarterly statements where they have something to compare, just as it may take another one of these annual disclosures in the comparative chart before we begin to get more questions. I think the assumption probably needs to be made that people are going to be learning, the average participant and beneficiary is going to be learning more about this. They may have been overwhelmed with the data last month, but as they begin to see something moving, rising or falling, they may not tell whether they're at flood stage or not, but they can tell whether the water's going up or down. So I would say let's have another conversation, Greg, in November and see. I hope that what folks are finding is that the charges look reasonable to them. Again, the whole point of all this is to require the fiduciary to fulfill his job and to make the service providers fulfill their jobs, to see that the arrangements are reasonable, that they're necessary for the operation of the plan, that no more than reasonable compensation is being paid. And if participants get a sense that, I'm not going to argue about a penny here or a penny there, but I think that generally it looks reasonable and someone is managing the accounts properly, then we've come out where we need to be. But let's see where we are in about another 2 months. Now, let's see. Forgive me here, I'm going to make sure we've caught up here. There are a number of obligations to disclose to the participants that the fiduciary has to meet without a specific date on the calendar that you can predict. An orderly and predictable schedule is a good thing. It enables us to take more time to do it in an orderly way and to make sure we've got it accurate and complete. But there are other disclosure duties under the regulations that may not give us that benefit of the extra time or a long-range planning period. I would venture to guess that the timeliness of disclosing it to the participant or beneficiary depends on when those rights have to be exercised. If there's going to be a proxy vote that has to be returned by X date, then you need to give it to the participant or fiduciary reasonably in advance of that they can act on it. But this has to be done with or without a request for this information by the participant or fiduciary. Now, upon request from a participant or fiduciary, beneficiary, the fiduciary must promptly provide any prospectuses or similar investment documents that come into the fiduciary's hands, a statement of value for a share or unit of each investment, any financial statements or reports provided, of course, that that information is disclosed to the plan itself, and a list of the portfolio assets and their values for the designated investment. Now, this says upon request. We know in an analogous situation that the participants or fiduciaries can ask for information about the plan, a copy of the documents that are used to manage the plan document, the summary plan description, and the like. And this doesn't have to be like every day. The plan can put into place some reasonable limit and can charge a reasonable amount for copies of those types of plan documents. And it's typical that you limit those types of requests, the responses to those requests, say to once a month or once a quarter. It would be reasonable to assume that something might be interpreted that way here, but the regulations don't give me a clear idea of how frequently the participant or fiduciary can come in and ask for this. It does not say exactly how much time, like within 30 days, the fiduciary has to respond. Although, again, if we look by analogy to the existing 502C requirements to respond to a request for plan documents or a summary plan description and the like, you normally have to get those done within 30 days. Otherwise, the plan administrator might be subject there to those civil penalties. If we take that as a benchmark, then normally you would expect to respond to these types of questions within 30 days. And again, try to find some reasonable balance in the frequency of how often you have to respond. I would guess that probably whatever request of that type you're going to get, the point, I think, is that for this type of situation, the participant or fiduciary probably is being driven to ask about this information by a certain situation. There is a particular investment they've heard about, or they've got a concern because they were talking at the coffee break in the office with somebody and they said, well, have you asked about X? And so they're probably going to not be coming in every week. Hopefully this will not be a burdensome requirement, but it's there. The fiduciary's obligation is to determine that the contract or arrangement is reasonable, that the services are necessary to the plan, that no more than reasonable compensation is being paid. Of course, there are reasons why this is important to the plan fiduciary, because an unreasonable contract or arrangement could expose the fiduciary to a prohibited transaction and penalties and taxes. So there is a real kicker in all of this and an obligation to act within a reasonable time and accurately. So simply saying, well, my provider didn't get the data to me when I needed it is not going to be enough. The fact that there was an oversight and a failure to deliver the information that the fiduciary needed is not going to get the fiduciary off the hook, even if it was inadvertent, unless it is cured. So when the fiduciary is vigilant and sees that certain data was supposed to come in, if you ask for something, you better keep track of that request and see if you've got a response. The fiduciary has to require that that omission or mistake be cured by the provider, that you actually get the data. You can't simply wait time, without going back and asking the service provider to bring the data in. You have to make a written demand for it, and it's always going to be wiser to document this, not simply do it over the phone. But to make a written demand, and I would say that an email can be accepted as a written demand, but a letter would also be a very good policy. Use that. And again, as we noted before in talking about the service provider requirements, if the service provider does not respond, and it's not just making a response, like I'll get back to you later, but if they don't respond and provide the necessary information within 90 days of the request, then the regulations do require the fiduciary to report this in writing to the Department of Labor, specifically to the Employee Benefit Security Administration. Effective last Friday, September 14, according to a press release that came out at the beginning of this week, the DOL will permit the fiduciaries to file these reports, to blow the whistle on the providers, online. There is an electronic notice that can be filed at the Department of Labor, the EBSC website, and I can show that to you if you would like to come up and see me right after this, or you can check for that press release. But look for a release dated September 14, 2012. It should be on the EBSA website. And if you would prefer not to send in these reports on the providers by an online report, they can be mailed in writing to the U.S. Department of Labor, the Employee Benefits Security Administration, the Office of Enforcement, P.O. Box 75296, Office of Enforcement, P.O. Box 75296, Washington, D.C. 20013. If the fiduciary does not carry out that notice and reporting function, then the fiduciary himself will be guilty of a prohibited transaction by failing to go get the necessary information from the covered service provider, and he's got to determine whether he should terminate the contract or arrangement with that provider. This all goes back to the fundamental rule of making sure that the arrangements are reasonable. A couple of things left. Again, go to your materials. We've had some agency guidance. Of course, a lot of the disclosures were sent out by email, but as you have seen, there are rules that have to be applied in order to satisfy the use of emails as a delivery system. It basically comes down to you have to contact the participant or beneficiary ahead of time to make sure you've got an accurate email address and that they will accept that by email. The safe harbor is a written notice to them by mail, but you again also have to be ahead of the game and make sure that you've got an accurate and up-to-date mailing address. Also, we've gotten reasonable guidance, certainly additional guidance from the EBSA about use of websites to put information out there. Of course, an internet site is required for certain basic information under the regulations already. If you will look at Field Assistance Bulletin 2012-02R, this is the revised Field Assistance Bulletin that came out at the end of July of this year, revising the original 2012-02 that was issued back in May. And look at it's in a question and answer format. Look at the questions 17, 18, and 19 of that Field Assistance Bulletin 2012-02R, and it will give you some practical guidance on what the department would accept in terms of using websites to put information out there. That also will be of interest to you, that particular Field Assistance Bulletin, because it corrected a position taken under question 30 of the original bulletin when it was issued back in May. Many of you will be aware of the, I won't say firestorm, but certainly the extreme level of irritation that was put out by many in the industry and the feedback that the department got, which required it to retract that question 30 and replace it with question 39 in the revised Field Assistance Bulletin 02R. All of that had to do with brokerage windows. And the bottom line I think that we can take away from this is that the Department of Labor is going to look with a very hard eye at any plan fiduciary who offers a plan with no designated investment alternatives but only a series of brokerage windows. There was an attempt in the initial Field Assistance Bulletin to almost promulgate a new rule through a Field Assistance Bulletin, which is not the appropriate way to put out a new rule, and that was one strong reason for the pushback. The department has retreated a little bit, but it's still clear that if a plan has only a series of brokerage windows or other brokerage accounts, then that's not going to be accepted as a reasonable arrangement of investment alternatives for the plan, and the fiduciary's own compliance with his obligations will be questioned by the department. So brokerage windows are going to be permitted, and certain information about them has to be disclosed, but there needs to be at least one designated investment alternative or more, and usually, as we know, the department's looking for 3 or 4 or 5 of those or more. This is not news to any of you, I'm sure. Good fiduciaries have always tried to have a reasonable range of investment alternatives that show a balance and give different types of investment returns and have characteristics that differ. But just be aware that the use of the brokerage windows, because they may seem to slip under the radar of the fee disclosure requirements, is being questioned by the Department of Labor. The Department of Labor also is intending to publish a notice of proposed rulemaking in the near future about covered service providers being required to issue a guide or similar tool to assist the fiduciaries to review all the data that the providers give to them before the fiduciaries then turn around and make the disclosures to the participants and beneficiaries. The last word that I had in the last screen that you've got is about the Tussey case. This is not directly involved with the fee disclosure regs, which kicked in this summer, but many of us looked at the case of Tussey versus ABB back at the end of March of this year when it was issued by a federal district court in Kansas City. We don't have time this morning to go through all of the interesting facts of that, although you can find some pretty good summaries on the web about that case. But you'll recall that the problem with the Tussey situation was that ABB had a very, very large 401k plan. It was getting help from at least a couple of the fidelity companies as record keeper and trustees. And over the years, and the problems apparently described by this case went on over a decade, there were all kinds of problems that emerged from too close and unquestioning a relationship between the plan administrator, the investments committee at ABB, and the outside service providers. And these give us some takeaways that we need to remember as we look at all of these fee disclosure requirements, because they're going to set the tone of how the federal agencies look at the fiduciaries and how plaintiffs or plaintiffs' attorneys in this field may look at them. Of course, you'll recall in the Tussey case, the plan administrator was accused, among other things, of allowing Fidelity to collect excessive service fees, to not even follow its own stated written investment statement, which required that a lot of the rebates be applied to offset the plan administrative expenses. That was not being done. It was also very much a problem for the judge that in one instance ABB's investment committee had taken out a reasonably well-performing Vanguard fund and had replaced that with what turned out to be a poorly performing Fidelity investment fund, which caused not only a poorer performance but extra charges to the plan participants. All of the details, again, are set out for you in that case or in some of the blogs, but one thing to remember is that at the end of the day, after a 4-week trial, the judge in that case imposed $37 million in damages, over $35 million for damages to the plan participants on ABB itself as the plan administrator, and $1.7 million on the Fidelity companies because there were certain points in which they were holding plan assets and they were held to be plan fiduciaries for those particular functions. Now, even though $1 million is not what it used to be, that size of a court judgment is beginning to sound like serious money, in the words of former Senator Dirksen. So we continue to need to keep vigilance in how we fulfill all of these duties. The assumptions that plan fiduciaries are always doing the right thing is probably well-founded, but it's going to be questioned. And we hear from many press releases and other information on the web that the Department of Labor is devoting more people and energy to sending out plan auditors, and they will be well aware of the issues that ABB versus Tussey case dealt with. So these words to the wise. Diligent observance of all the fiduciary duties is crucial. That applies certainly to these fee disclosure requirements. And the plan fiduciaries will be held to account. In general, if the service fees are going up, a plan fiduciary should ask the providers why. The fiduciary should also periodically ask, are there less expensive and better performing investment alternatives that would better serve the participants? An orderly process, a good deliberative system, vigilance on the part of the fiduciaries, responsiveness and competence on the part of the providers should enable all the plans to get through this new regime of disclosures successfully, but it will take some time and attention. Those are the remarks that I had prepared. Do any of you have any questions, any further questions about any of that? All right, well, thank you. Please do remember to give us your evaluations for this seminar and fill out the continuing ed forms if you would like to get credit. And by all means, give us some ideas of things that you would like us to be speaking about at the next one of these seminars, which we will probably bring to you early in the new year. Thanks very much.